I'm very honored to welcome as a second speaker Professor Ashley Deeks. Ashley is currently teaching international law at the University of Virginia Law School. She's also a senior contributor to the Lawfare blog that I'm sure a lot of readers are among us today. You're going to talk about the international law framework for foreign surveillance.
Yes.
Ashley.
Thank you very much. Thanks both to CyCon for allowing me to participate, and thank you also to Pascal for pulling together this particular panel. So today we're talking about electronic surveillance, which has obviously garnered a lot of attention in the wake of the Snowden leaks, and in large part because of the Snowden leaks. And a lot of the discussion, at least in the United States, has really focused on what US domestic law has had to say about the US government conduct of electronic surveillance. We've talked a lot about the Patriot Act, Section 215, which remains a topic in the news for the next week or so, as well as the FISA Amendments Act, Section 702, which also relates to what you may have heard of as the PRISM program. But as many of you may know, most states have far fewer domestic regulations that govern their overseas spying. So to the extent that we are starting to think about whether that's a desirable or a sustainable state of affairs, one place to start is to ask, well, does international law do any work here already, and or should it do more work in the future? So one question that I've been wrestling with is, what does international law have to say about foreign electronic surveillance now, if anything? And what should states make changes on the international plane to regulate the conduct of this foreign electronic surveillance that has been so in the news lately? So where I want to start is to argue that international law on electronic surveillance, and particularly foreign electronic surveillance, is quite limited. International law has long been thought not to say very much about spying. Some of you may have been at an earlier panel where the speaker referenced there being one rule of international law on spying, and that is not to get caught. And when I'm talking about spying, I am talking here about spying generally, whether it's human intelligence collection, covert action, or electronic surveillance. So there are three schools of thought on international law's role related to electronic surveillance. So the first two schools, I think, that are all listed as number one, so school one and school one, have been the most dominant view until quite recently, I think. So the first school is that international law affirmatively contemplates and permits spying. The idea here is that spying furthers a state's right of self-defense and is implicit in its ability to defend itself. The second school is that international law is really quite agnostic on spying. This picks up on the Lotus principle in international law, which says that which is not prohibited by international law is therefore permitted to states. And both of these schools, when asked to defend these positions, tend to point to state practice. And they say, look, for hundreds of years, spying between states has been widespread, pervasive. Everybody who can do it does it. This is true both before the UN Charter and after the UN Charter, and among different states located in different geographic areas. The third school, which I think has been the minority view but is picking up some energy and steam, is that there are actually provisions in international law that prohibit or regulate spying. One category of international law that some have invoked is customary international norms related to sovereignty and territorial integrity. A second set of norms that has been invoked, particularly with regard to electronic surveillance, is the human rights regime, and particularly the International Covenant on Civil and Political Rights. Article 17 of that treaty states that no one shall be subjected to arbitrary or unlawful interference with his privacy, family, home, or correspondence. And of course, the European Convention on Human Rights has the equivalent, which Lee just referred to. So that's the second category of argument that international law, as it currently exists, does some work to regulate spying. And the third category of international law that some states have recently invoked in pushing back against foreign surveillance is the Vienna Convention on Diplomatic Relations, which includes provisions providing protection to a foreign embassy, not allowed to intrude into it as the host state. And another provision requires sending states to comply with the domestic laws of the states in which they are operating, and many states have domestic laws prohibiting spying. So those are arguments that have pretty recently come out in support of School 3. But I think it's useful to think about why international law generally has not been thought to address spying. So I think there are at least 5 reasons why this is the case. So the first is that we should ask, why do states spy? Well, states spy to protect their core national security interests. They're really core interests, these primary equities. And so states, therefore, might be expected to be more nervous about allowing rules to come into play that constrain that activity. A second reason is that spying, by definition, is supposed to be hard to detect. So therefore, you might think it would be difficult to enforce treaties that regulate spying between or among a group of states. If it's hard to detect, you might expect that states will be loath to enter into these agreements in the first place. Third, there is an understandable reluctance to discuss capabilities. Yet, when you come to negotiations and you talk about spying, it's hard to do that without some kind of reference to what you're talking about and how you might do it. And states are not interested in sharing their sources and methods with any but their closest partners. A fourth reason I think that international law has not traditionally been thought to address spying is that there's such a wide variety in capacity among states to spy. And that creates variable incentives. So states that are particularly good at spying might be less interested in reaching agreement, and states that tend to feel as though they are the victims of spying would actually like to enter into some sort of arrangements to regulate that activity against them. Finally, and I think this is important for my comments today, spying, I think, used to be more costly, more financially costly, and really tended to be directed at states and state actors. As a result, I think there was limited public interest and public pressure in spying because the average person didn't feel as though he or she was directly affected by state-to-state spying. Okay. So I think we're now starting to see some shifts. And I think those shifts, I can identify sort of 2 areas in which we're seeing these shifts. The first is a shifting form of intelligence collection, right? We have new targets. States are very interested in counterterrorism, counterproliferation. The targets in that context tend to be non-state actors. New tools, we've heard a lot about, and I think everybody in this room knows that there are new tools related to cyber that allow states to do more with maybe with less. And the second shift is a shifting understanding, I think, of the existing international law rules. So the first shift, as I suggested, I think is driven by the rise of international terrorism and the role of non-state actors. So this led to an expansion of what states felt that they needed to collect. States could no longer focus on foreign states and foreign officials alone. They needed to look for communications by non-state actors that were potentially engaged in terrorism and related activities. Well, what does that mean? Well, that means that states then end up sweeping in different and broader types of communications in their surveillance. And that, as we know, can include many individuals who are not implicated in or suspected of terrorist activities. So suddenly, the average individual has a stake in spying, where I think that those individuals didn't have the same stake before. And yet, I think these new security threats suggest to us that states are not just going to roll over and stop electronic surveillance. In fact, I think they see these threats as especially serious. So I think we are going to continue to see electronic surveillance into the future. So that's the first shift, is the sort of targets of surveillance. But the second shift, which is a little bit, they're related, because I think the second shift is in part triggered by the first shift, is what I call a repurposing of existing international law. So I don't mean to suggest that states never contemplated that international law had anything to do with spying. If you look historically, you can find a couple of episodes in the history books where one state accuses another of violating international law by virtue of their spying activities. So the USSR shoots down the US U-2 aircraft that was spying on it in Soviet airspace. The Soviets alleged that that was a violation of international law, territorial integrity. But more often, there are few explicit public discussions about this. Often what happens is one state will just, if it detects people spying on it, it will declare them persona non grata, send them out of the country, and that tends to be the end of the public conversation about it. But I think these shifts warrant new thinking about the role of international law in regulating spying. One approach that we've seen, and this is one that human rights groups are taking, is to push for a robust application and extension of existing human rights provisions drawn primarily from the ICCPR. That is, that states should not be engaged in unlawful or arbitrary violations of the right to privacy, either of their own citizens or of any citizen, meaning they would apply this treaty extraterritorially. But I think states are still, particularly the US, but I think some other states, are still disputing the parameters of those rules and the essence of the substantive right to privacy, and what exceptions should attach to that right. Okay, so I want to argue now that I think it's in states' interests to consider international regulation. If you're a hardcore realist, you might disagree. You just say, let's keep going business as usual. I'm not sure that's the right approach. And I think, so the approach I'm going to suggest, I think is actually complementary to the approach that the human rights groups might be taking. But my idea is that states may want to think about adopting new international norms to regulate extraterritorial surveillance that are focused on process rather than substance. One reason to think that this might actually get some traction is that almost all of the forces outside of government are pulling in the same direction on this. So we see pressures on states, particularly the US, the UK, Australia to some extent, pressures from the UN, pressures in the International Court of Justice, corporations in particular, foreign leaders, and foreign publics. Even some within governments themselves, and I can give you some examples from the US perspective, are pulling that way as well. We have seen some unilateral changes within the United States that are trying to create a slightly more privacy protective surveillance regime. And I think that some of the 5 reasons that I identified earlier about why states have been agnostic about regulating spying have shifted a bit, right? So I think to some extent, some of the secrecy, the deep secrecy that was protecting these activities has lifted a little bit, not because states wanted it to, but it's lifted nonetheless. And I think there's greater political pressure to regulate. I think it's arguably in the interest of states, at least in the interest of Western states, to impose on themselves some limitations in this area. So if some states in a given alliance are under either legal or political pressure to limit cooperation with their partners, as long as their partners are doing things that they deem unlawful or otherwise problematic, establishing a common set of basic rules could help ameliorate that problem. It might diminish conflict among states proper, right? So the accusations of spying that some have mentioned previously in the Angela Merkel situation, the Dilma Rousseff, that could be diminished. Domestic constituencies, including particularly corporations that believe they're losing business as a result of the Snowden leaks, are demanding it. And states are potentially losing the moral high ground. You can see in Obama's speech from 2014 a concern about, it's an instrumental concern, frankly, but a worry that without some idea that the US is acting in a lawful and legitimate way, it's going to have a harder time doing what it thinks it needs to do. I do want to make the point that I'm not suggesting all states would come on board. This is not a story about 194 states. I think there is a vast divide at this point between the West and states like China or Russia, differences politically, different political pressures that each state feels, different self-conceptions and different levels of trust among the states. And I think Western states will not hamstring themselves unilaterally. I don't argue that states are going to adopt these procedural norms just because it's the right thing to do. I think more likely what we would see is a limited agreement among similarly situated states, with others maybe adhering to those norms later on. So let me say in my last 3 minutes, give you a sense of what possible norms I'm talking about. In developing these norms, what I did is I looked at the domestic laws of a number of states that had the most extensive regulations of their domestic surveillance and transnational surveillance, that is, surveillance of communications that may be coming from or to abroad, or communications that happen entirely abroad but happen to loop through the country that's collecting them. I think these norms are tested, they've been publicly debated, they're largely statutorily incorporated in these states' laws. So the 6 norms that I have suggested are these. The first would be legality and notice of the applicable rules that we're talking about. The rules should be established by law and basically put people on notice of who is potentially subject to electronic surveillance and why. Second, I think states should establish some limits on either the reasons to collect data or the ways in which they use data, right? So these are referred to as either collection limits or use limits. States have some of these now. Some of these states provide discrete lists of reasons why they're allowed to collect or use surveillance data, detect counter-espionage, defeat proliferation of WMDs, transnational criminal threats, and so on. Can't violate an attorney-client privilege, for example, is another one. And states like the US and UK say we're not going to use this surveillance information to advantage our own domestic corporations. So that's the second one. The third one would be a periodic review of surveillance authorization so that once authorized, the surveillance doesn't continue indefinitely. Fourth, I think you could agree to limit how long you retain data. And Lee may have some thoughts about whether that's something we'll see in any of the directives. Fifth, I suggest there should be a preference for domestic action. Well, what do I mean by that? If the state that's interested in obtaining surveillance on a particular actor who's in a given state, has a good relationship with the state in which that person's located, we should encourage that territorial state to conduct the surveillance. Why? Well, chances are that those rules are more rights protective. And so you could, in a friendly state situation, defer to the domestic actor. And finally, I think the existence of neutral oversight bodies is really sort of a sine qua non. You could have it ex ante, you could have it ex post, you could have both, but establishing at least a requirement there be one or more of these kinds of bodies. As I said, you could view this as an alternative approach to where I think some of the human rights groups are advocating, but I think it's arguably not in tension with the human rights agenda. I think those groups inevitably will continue to pursue their efforts to shape the substantive rules, but I see these norms as potentially effective placeholders while that shakes out, which will take some time. So with that, I see I'm out of time. So thank you very much.
Thank you. Thank you, Ashley, for your take on international surveillance.